6 October 14, 2025, Boise, Idaho. A single US Marshals Service vehicle pulled into the parking structure next to the Ada County Courthouse. No lights, no markings beyond the standard government plate. Inside, Deputy Marshal Constance Reyes sat with a manila folder open across her lap and a name circled in red ink at the top of the first page. The name belonged to a federal judge, a man the system had declared dead 11 months earlier. Estimated cost to the federal judiciary's integrity investigation undisclosed. Estimated personal assets moved offshore in the 18 months before his disappearance, $4.2 million. Estimated time he had been living freely under a fabricated identity while federal warrant processes sat frozen in 3 separate jurisdictions, 17 months. Reyes closed the folder. She had one lead, one property transaction, one thread connecting a dead man to a coffee plantation in the Guanacaste province of Costa Rica. She pulled out of the parking structure at 6:31 a.m. and drove toward the federal building. The work was just beginning. This is the story of how the United States Marshal Service spent 17 months dismantling a staged death, following a financial ghost trail through 4 jurisdictions and 2 American embassies, and finding a federal judge who had spent 31 years inside the system, learning every weakness it contained. A man who almost used that knowledge to disappear permanently, almost. The subject of this investigation was United States Bankruptcy Court Judge Raymond Foell, appointed to the District of Idaho Federal Bench in 1994, confirmed without controversy, 31 years of service, 2 commendations from the Federal Judicial Council, a reputation among practitioners as exacting, procedurally consistent, and difficult to read in contested matters. He was also, as investigators would later determine, the primary subject of a sealed corruption inquiry that had been building inside the Ninth Circuit's internal review apparatus since the spring of 2025. Foell was 63 years old when he vanished. No children, one ex-wife remarried and living in Portland. A modest home in Boise's North End neighborhood appraised at $412,000. A judicial pension that would have paid him comfortably into his 80s. On the surface, there was no reason for a man of his standing to run. Beneath the surface, there was every reason. The sealed inquiry into Foell's conduct had originated from a complaint filed in March 2025 by a bankruptcy trustee named Patricia Warren. The complaint was specific and documented. It alleged that over at least 4 years, Foell had systematically favored certain creditor-side law firms in high-asset bankruptcy proceedings, steering asset liquidation outcomes in ways that generated disproportionate fee recoveries for a small cluster of firms while shortchanging creditor classes that lacked political or professional connections to his circle. The mechanism was not crude bribery, no envelopes, no direct payments. Instead, the investigation alleged a pattern of procedural favoritism, scheduling advantages, evidentiary rulings, the selection of trustees in contested cases that created compounding financial advantages for a network of attorneys and financial professionals who maintained relationships with Foell through personal and professional channels that investigators were still mapping when he disappeared. The dollar figure attached to the preliminary assessments was significant. Across 18 identified cases spanning 2021 through 2024, the alleged steering had affected asset distributions totaling approximately $67 million. The firms that benefited had received fee awards substantially above comparable proceedings in other districts. $67 million in affected distributions. That number would anchor everything that followed. Warren had brought her complaint to the Ninth Circuit's Circuit Executive's Office in March 2025. By April, the inquiry had been elevated, sealed, and assigned to a review panel operating outside of Idaho's district entirely. The panel worked in San Francisco. Foell, by all available evidence, did not know the inquiry existed. Then something changed. In late May 2025, investigators on the review panel detected what appeared to be a procedural anomaly in communications logs from Foell's chambers. The details remain under seal. What is not under seal is what happened next. Within 30 days of that detection, Raymond Foell began taking steps that would, in retrospect, look like preparation for departure. He did not know his review panel was watching, but someone had told him the walls were closing in. Who that someone was has not been publicly established. June 2025. Foell submitted a request for a 30-day medical leave, citing a cardiovascular monitoring protocol his physician had recommended. The court administrator approved it without scrutiny. A federal judge of his seniority requesting routine medical accommodation was unremarkable. During that 30-day period, Foell took 4 trips. 2 were documented in personal accounts and credit card records that investigators would later pull, 2 were not. The documented trips were to Portland, ostensibly to visit his former law school, and to Las Vegas for what his calendar described as a bar association dinner. Both trips involved cash withdrawals at ATM locations. Both trips involved Foell spending time in areas not consistent with his stated itinerary. The undocumented trips were to Central America. Foell had traveled to Costa Rica twice before, in 2018 and 2021, both times on a standard U.S. passport with travel records filed normally. In June 2025, he traveled under a different document. The construction of that second identity had begun, investigators would later determine, no later than January 2025, 3 months before the sealed inquiry formally opened. This timeline created one of the most significant analytical puzzles in the case. Either Foell had been planning his exit for reasons predating the inquiry, or he had known about the inquiry before it was formally initiated. That question remains unresolved. What investigators established with certainty was that by late June 2025, Foell had identified a property in Costa Rica, a working coffee plantation of approximately 40 acres in the highlands above the town of Liberia in Guanacaste province. The property had last changed hands in 2022, when it was purchased by a Costa Rican agricultural holding company. In June 2025, that company transferred a 51% operating interest in the plantation to a second entity. That second entity was registered in Panama. Its beneficial owner, as listed in the filing, was a name no one in the United States had ever heard. The name was Adrian Conejo Marchetti. Adrian Conejo Marchetti did not exist prior to approximately January 2025. His documentation, Costa Rican residency papers, a Panamanian business registration, a secondary identity layer involving a Canadian travel document issued through a process investigators are still reviewing, was assembled over roughly 5 months. It was not a crude forgery. It was a constructed identity with enough institutional depth to pass routine scrutiny at border crossings and banking compliance windows. It was also expensive. The forensic financial analysis would later estimate that the full identity construction and property acquisition had cost Foell between $200,000 and $300,000, paid through a layered series of transactions involving cryptocurrency conversions, wire transfers through 2 Central American banks, and at least one intermediary who has not been publicly identified. Foell returned to Boise from his second undocumented trip on July 2, 2025. He resumed his judicial duties. He heard cases, he signed orders, he attended a retirement dinner for a colleague at a downtown restaurant. By every external measure, he was a functioning federal judge with no unusual profile. 31 days later, he was dead. Or so the record stated, August 3, 2025, a Sunday morning. Foell's vehicle, a 2021 Subaru Forester registered to him, was found at the trailhead of the West Fork Moores Creek Trail in the Boise National Forest. His gear was in the vehicle, his wallet was on the driver's seat. His cell phone was in the glove compartment, powered off. A search was initiated that afternoon when the vehicle was reported by a ranger who had seen it unmoved since the prior morning. Search and rescue teams from Ada County, Elmore County, and the Boise National Forest Service deployed over the following 4 days. The terrain was rugged and steep. The West Fork drainage had been running high from late summer precipitation. Searchers covered approximately 12 square miles. No body was found. The official determination issued by the Ada County Medical Examiner's Office on September 19, 2025, was presumed accidental death by drowning or trauma following a fall in the Moores Creek drainage. The finding was consistent with the conditions and with the evidence as it appeared. It was also entirely a construction. Foell's life insurance policy, a $1.2 million term policy held with a carrier based in Hartford, paid out to the designated beneficiary, a charitable remainder trust that Foell had established in 2019. The carrier conducted a standard review. The medical examiner's determination was sufficient. The payout cleared on October 8, 2025. By that date, Raymond Foell was already in Costa Rica. His case file at the Ninth Circuit Review Panel was suspended pending resolution of his status. The sealed inquiry went dormant. Without the subject available, there was no path to proceed. The panel filed administrative notices, notified the presiding judges of the affected district, and placed the matter in abeyance. The system had worked exactly as Foell had calculated it would. Then, 11 days after the insurance payout cleared, something moved. October 19, 2025. The US Marshals Service Warrant Tracking Division in Arlington, Virginia received a routine data feed from the Panamanian corporate registry, a feed that ran as part of a treaty-linked compliance data sharing agreement established in 2018. The feed was not specifically targeted at Foell. It was part of a broader sweep for names associated with open federal matters. The name Adrian Conejo Marchetti appeared in the feed because it was attached to a Panamanian entity that had, through a chain of ownership that took investigators 2 weeks to fully trace, a filing connection to a US-linked financial account that had appeared in a completely separate money laundering investigation out of Miami. The Miami connection was a coincidence, a bureaucratic accident, the kind of overlap that produces one hit in 10,000 sweeps, but the sweep ran the name flagged. A junior analyst in the warrant tracking division named Kyle Ostrander was assigned to run a preliminary check on the connection. Ostrander spent 3 hours on the Conejo Marchetti identity before concluding that it was almost certainly constructed. The documentation was internally inconsistent in ways that experienced identity fraud analysts recognize: minor temporal mismatches in institutional records, a slightly too clean paper trail with no organic gaps or amendments. He escalated. The case moved to the Fugitive Apprehension Strike Team Division. The strike team began with what they had: a Panamanian entity, a Costa Rican property transaction, and a constructed identity. They began working backward. This is where the investigation became genuinely difficult. Foell had been careful. The property transaction was not directly linked to any U.S. identity. The financial chain had multiple breaks, points where cash or cryptocurrency had been introduced to sever the trace. The identity construction used documents from jurisdictions with limited U.S. treaty access. And Foell was by profession and experience a man who understood exactly how federal investigations built paper trails. He knew what investigators looked for because he had spent 3 decades watching federal investigators present that evidence in his courtroom. The first 3 months produced very little of direct evidentiary value. The strike team established the probable construction of the Conejo Marchetti identity. They established the Costa Rican property connection. They established that the property was actively operational. Recent satellite imagery showed agricultural activity, vehicle movements, and what appeared to be renovation work on the main residential structure. But they could not, in those first 3 months, place Raymond Foell at the property. Then came the obstacle that nearly ended the investigation entirely, January 2026. The strike team's primary analytical thread, a financial trace running through a correspondent banking relationship in Panama City, went cold when the Panamanian bank in question suspended operations following an unrelated regulatory action by Panamanian financial authorities. The bank's records, which had been the subject of a mutual legal assistance treaty request filed in November 2025, became inaccessible as the institution entered a legal dispute with regulators over the scope of the suspension. Weeks of work stalled against the wall of foreign regulatory procedure. The strike team Supervisory Deputy Marshal James Whitcomb, made a decision that changed the investigation's direction. He pulled the financial thread and pivoted to physical surveillance. A two-person team was deployed to Costa Rica in early February 2026 under State Department liaison coordination. They were not there for an arrest. They were there for one purpose: to establish or rule out the physical presence of Raymond Foell on the Guanacaste property. The surveillance lasted 11 days. On day 7, one of the two deputies, a deputy named Andrea Solano, who spoke fluent Spanish and had conducted prior Interpol-linked surveillance operations in Latin America, was positioned at an outdoor market in Liberia when she observed a man matching Foell's general physical description purchasing produce from a vendor she had identified as a regular supplier to the plantation. The man had a beard, he wore a broad-brimmed hat, his Spanish was accented and limited, he paid in cash. He was approximately 63 years old, approximately 6 feet 1 inch in height, and had a scar on his left forearm consistent with a scar documented in Foell's federal employment medical file. Solano did not approach. She photographed him from 40 meters using a concealed long-lens setup. She transmitted the images to Whitcomb in Arlington within the hour. The biometric comparison took 4 days. Facial recognition algorithms applied to the market photographs against Foell's official judicial identification photos returned a probability assessment of 91.4%. That figure was not sufficient for a warrant on its own, but it was sufficient to change everything else about the investigation's priority level. The case was elevated to the Marshals Service's International Fugitive Recovery Division. The State Department's Diplomatic Security Service was formally briefed. The embassy in San Jose was notified. And the Ninth Circuit's sealed inquiry, dormant since September, was reactivated and expanded. What investigators did not know yet, what they would not learn until the arrest itself, was that Foell had already detected the first surveillance operation. He had not identified the deputies. He had identified the pattern. A surveillance-aware subject who had spent decades watching federal investigators work recognized the behavioral signatures. A vehicle that appeared twice near his supply route. A face at a market that reappeared at a roadside stop 3 days later. Minor inconsistencies in the rhythms of a small regional town he had not run. That was the mistake that would cost him. Later analysis suggested he had calculated that running again would signal confirmed awareness of surveillance, which might accelerate the legal process against him. Staying, he apparently judged, gave him time to assess whether the surveillance was specific to him or part of a broader operation that might not be definitively linked to his identity. It was a logical calculation. It was also wrong, because while Foell was assessing whether to move, the Marshals Service was building a case that no longer needed the financial threat at all. The pivot came from an unexpected direction. March 2026. The strike team's liaison at the IRS Criminal Investigation Division, which had been conducting a parallel review of the life insurance payout at the Ninth Circuit's request, surfaced a detail that had been sitting in the record since October 2025 without anyone recognizing its significance. The charitable remainder trust that had received Foell's insurance payout, the $1.2 million beneficiary designation, had been established in 2019 with a Costa Rican legal entity listed as the administrative trustee. The administrative trustee was a law firm based in San Jose, a firm that, according to public bar registry records in Costa Rica, had one attorney with significant experience in agricultural property transactions in the Guanacaste region. That attorney's name appeared as a signatory on the 2025 property transfer documents for the plantation. The same attorney, the same transaction. The insurance payout and the plantation acquisition connected through a Costa Rican law firm that had been sitting in the public record of Foell's own trust documents since 2019. Foell had used his own pre-existing legal relationship to facilitate the property acquisition. He had trusted in the complexity of the paper trail to prevent the connection from being seen. But complexity is not invisibility. That question came up repeatedly among the investigators who worked this case. Did Foell calculate that the system's bureaucratic fragmentation would protect him, or did he simply believe no one would look hard enough? The attorneys at IRS-CI flagged the connection on March 11, 2026. Whitcomb received the analysis at 9:47 a.m. He read it twice. He called the International Fugitive Recovery Division chief. "We have him," he said. The arrest operation was not simple. The Guanacaste plantation was in a rural zone with limited law enforcement infrastructure. Costa Rican jurisdiction required active cooperation from the Organismo de Investigación Judicial de Hoy, Costa Rica's primary investigative police authority. An extradition framework existed between the US and Costa Rica under a 1982 treaty, but arresting a judicial fugitive on foreign soil required careful legal coordination to avoid procedural defects that could later complicate extradition proceedings. The strike team's legal coordinator spent 3 weeks working through the framework with OIJ counterparts and the U.S. Embassy's legal attaché in San Jose. A provisional arrest warrant was sought through Costa Rican court processes supported by the biometric identification and the financial trail documentation. The warrant was issued on March 28, 2026. The operation was set for April 4, 2026. Meanwhile, the investigation had also been quietly tracking a second question: the source of the leak that had apparently warned Foell about the sealed inquiry in spring 2025. If Foell had known about the inquiry before it was formally opened, someone inside the review apparatus had told him. That investigation, a separate counterintelligence track running inside the Ninth Circuit's Inspector General's office, was ongoing and would not produce results before the arrest. It would produce results afterward, but that comes later. April 4, 2026, 5:44 a.m. Guanacaste Province, Costa Rica. 8 OIJ agents and 2 U.S. deputy marshals moved up the access road to the plantation in 2 vehicles. The OIJ operation commander, a senior inspector named Rodrigo Ulade, had conducted the operational briefing the prior evening at a safe location 12 kilometers from the property. The plan was straightforward: approach before dawn, establish a perimeter, make entry at first light. The residential structure was a converted plantation manager's house, a low concrete building with a wraparound porch, approximately 1,800 square feet, positioned at the northeast edge of the upper cultivation terrace. Thermal imaging from an OIJ drone the prior evening had shown one heat signature inside, stationary, consistent with sleep. The vehicle stopped 400 meters from the structure at 5:51 a.m. The team moved on foot through the coffee rows in the pre-dawn darkness. The air was cool. The plantation's irrigation system ran automatically in the overnight hours. The sound covered their approach. Ulate positioned 4 agents at the rear of the structure, 2 agents and 1 U.S. deputy at the front door. The second U.S. deputy, Reyes, the same Constance Reyes who had been in that parking structure in Boise on October 14th, 6 months earlier, held a position at the access road to prevent vehicle departure. At 6:08 a.m., Ulate knocked on the front door. He identified himself in Spanish. He stated that he had a warrant for the arrest of Adrian Conejo Marchetti. Inside the structure, nothing moved for 11 seconds. Then a light came on. The door opened at 6:10 a.m. Raymond Foell, unshaven, wearing civilian clothes, physically unchanged in any significant way from his official judicial photographs, stood in the doorway and looked at the agents assembled on his porch. He did not speak, he did not run, he raised his hands. He was taken into custody without incident at 6:11 a.m. on April 4, 2026. The OIJ arrested him under the provisional warrant. U.S. deputies were present as witnesses and to facilitate the identification process. Foell's fingerprints were taken at the OJ Field Station in Liberia at 7:30 a.m. They matched the federal employment records on file for Raymond Aldis Foell without any ambiguity. He had been living on the plantation for approximately 8 months. A search of the residential structure conducted by OIJ agents over the following 6 hours produced a significant volume of material: personal documents in 2 identities, a laptop computer with encrypted partitions, approximately $47,000 in cash held in a fireproof box, a second passport in a 3rd identity, a different constructed name, different nationality, different legal architecture from the Conejo Marchetti identity, suggesting Foell had maintained a second escape route. The cash and the 3rd identity indicated preparation for another disappearance. Whether Foell had been actively planning to move before the April 4th arrest, or whether the materials represented contingency insurance he had assembled and not deployed, was not determined from the evidence alone. The plantation's agricultural operation, investigators noted, was genuinely functional. Foell had employed 4 local workers. The coffee crop was in reasonable condition. He had spent money on equipment maintenance and irrigation upgrades. Whatever else he had been doing in those 8 months, he had also been running a legitimate agricultural business. That detail would later be cited by his defense team as evidence of settlement intent rather than continued flight posture. Prosecutors characterized it differently, as a cover operation designed to create the appearance of a stable civilian life while maintaining documented exit infrastructure. The extradition process began formally on April 7, 2026. Costa Rica's extradition framework with the United States required a formal request through diplomatic channels, review by Costa Rican courts, and a determination that the charges met the treaty's dual criminality requirement. The charges filed against Foell, obstruction of justice, wire fraud in connection with the insurance claim, flight to avoid prosecution, were all cognizable under Costa Rican law. The process was expected to take between 60 and 90 days. Defense attorneys representing Foell in Costa Rican proceedings filed challenges on jurisdictional and procedural grounds. Then came the development that no one in the US Marshals Service, the Ninth Circuit, or the Department of Justice had anticipated. The development that turned what was already an unusual case into something structurally more significant. The 3rd identity documents recovered from the plantation, the second escape passport, were traced by document forensic analysts to a forgery network that had previously produced identity documents for 3 other individuals, all of whom had federal matters pending in U.S. courts at the time of their respective disappearances. 2 of those cases had previously been attributed to subjects leaving the country on their own, using legitimate travel documents. The 3rd was an unsolved fugitive matter from 2021. The document network, 4 fabricated identity packages linked to a single production source, suggested an organized service providing judicial and law enforcement fugitives with exit infrastructure, not a criminal enterprise serving street-level criminals. A tailored service for white-collar subjects facing federal exposure. Where that network originated, who operated it, and how many other clients it had served were questions the investigation could not answer by the time this account was compiled. Foell's extradition proceedings remained active in Costa Rican courts as of early June 2026. His challenge filings had delayed the process beyond the initial 60-day estimate. A determination was expected before the end of the summer. The Costa Rican law firm whose attorney had facilitated the plantation transaction had not been charged with any offense as of the date of this account. The firm denied knowledge of its client's true identity and stated that all documentation presented to them had appeared valid. The Ninth Circuit's Inspector General investigation into the source of the 2025 leak, the person or persons who had warned Foell about the sealed corruption inquiry before it was formally opened, had not produced public charges as of early June 2026. The investigation was described in court filings as ongoing. The corruption inquiry itself, the original Warren complaint, the 18 cases, the $67 million in allegedly steered distributions had been formally reactivated and was proceeding as a parallel track to the criminal charges arising from the flight. The practitioners and firms identified in that inquiry had received civil investigative demands. Several had retained counsel and declined to cooperate voluntarily. Patricia Warren, the bankruptcy trustee whose complaint had started everything, gave a brief statement to reporters outside the federal courthouse in Boise when the arrest was announced. She said she had not expected it to take this long. She said she hoped the underlying conduct would be fully examined. The insurance carrier that had paid out the $1.2 million policy filed a civil recovery action in federal court in late April 2026. The charitable remainder trust that had received the funds was the named defendant. The workers at the Guanacaste Plantation, 4 Costa Rican nationals who had been employed by the man they knew as Adrian Conejo Marchetti, were interviewed by investigators after the arrest. They described him as a quiet employer reserved. He paid on time and in cash. He did not socialize with staff or neighbors. He spent evenings on the porch reading. He had no visitors in the months they had worked for him. One worker said he had seemed like a man who was waiting for something to be over. Raymond Foell had spent 31 years as an officer of the federal judicial system. He had processed thousands of cases. He had decided hundreds of millions of dollars in contested assets. He had issued rulings that shaped the financial outcomes of businesses, creditors, and individuals across the District of Idaho. He had also, according to the allegations that drove him to run, spent at least 4 of those years using that position for personal benefit. When the accounting became imminent, he deployed everything the system had taught him, its timing, its bureaucratic gaps, its cross-jurisdictional blind spots, in an attempt to disappear from it entirely. The attempt failed because of a routine data feed, a name in a Panamanian registry, an analyst who looked twice. Was it enough? The corruption inquiry is still open. The extradition is contested. The identity network that produced his escaped documents is not dismantled. The person who warned him in the spring of 2025 has not been identified. If you've worked in or around the federal court system and have seen patterns like the ones described in this case, drop a comment. This channel reads them. The investigation is not finished. Neither is the accounting. Subscribe if you want to know what comes next. The extradition ruling is expected before the end of the summer, and when it comes, we'll have the full picture. The Guanacaste coffee plantation remained under IJ administrative hold as of June 2026. The crop was still growing. Foell was in San Jose in a detention facility, waiting to see whether the system he had spent a career inside would bring him back.